Minos MOUZOURAKIS van ECRE, die daar Head of Legal and Policy Research is. En die gaat ons een state of case brengen zo van de CEAS en van de 2 scenario's die op dit ogenblik voorliggen in zaken Dublin. En hij gaat ook nog iets zeggen over de standpunten die onlangs zijn voorgelegd door Frankrijk en Duitsland. Meneer De Brouwer heeft er ook naar verwezen. En hun impact op de nieuwe commissie. Alsjeblieft.
Thank you very much, and thanks for the invitation today to this very interesting and very much needed and timely conference. I'm extremely grateful to our keynote speaker for laying out the main tenets of what we're discussing in terms of asylum, the timing of the new commission, the new institutions, but also the multitude of proposals, potential new ideas, and potential old ideas dressed in clothes of new ones. I won't bore you with the details of what we heard in terms of potential changes to responsibility sharing. One thing that is interesting to us as far as these new proposals are concerned, coming either from the Commission side or from some of the so-called non-papers of member states, concerns what would probably be happening before any mention of sharing responsibility. So, as you've probably followed, the stalemate in discussions on Dublin and also on the asylum procedures regulation led, probably as a perverse effect, to a re-emergence of border procedures as a magic bullet. So this idea came about that member states could agree upon very fast procedures at the external borders of the EU, whereby we would be able to filter quickly and efficiently who is in need of protection and who ought to be returned. And that would then ease off potentially the pressure on the rest of the member states. And that is something that kind of runs like a golden thread throughout all the different proposals. It was, of course, in the Commission's proposal in one version back in 2016. We called this pre-Dublin checks at the time, whereby before triggering the responsibility criteria, certain checks would be made on safe third country, on accelerated procedures on certain grounds. And also if we look, for instance, at what has been proposed with the German non-paper, we see again wording that could suggest that. We see wording relating to initial assessments of applications before then embarking on discussions on who should go where. Another non-paper, and again, I'm so sorry about quoting non-papers, I should also probably not even have access to them, that is put forward by the French delegation, very much echoes that approach. We have this notion of the border procedure being used as a mandatory part of the process at the external Schengen borders, interesting connection with Schengen as we heard this morning, as a prerequisite to any functioning asylum system. Now, 3 thoughts that I think would be interesting to raise. 2 legal considerations, 1 more political. First of all, what would be the implications of proliferating border procedures? That would mean systematic mass deprivation of liberty at borders, confinement of refugees, migrants, anybody seeking protection for the purposes of this part of processing. We don't even need to just look at Greece. Greece is, of course, the example that it is. It's an extremely mediatized one and an extremely critical one. But you can also look at examples of border procedures in other countries, including Belgium, including France, including Germany. Border procedures, to our understanding, are not necessarily possible to put in place without an element of confinement. So that can create very strong concerns when it comes to human rights compliance. Another thing that is very often overlooked is the quality dimension and the efficiency dimension from an authority's point of view. There's quite a bit of evidence as to how border procedures work in the different countries, including the ones I mentioned, and well-documented systematic concerns about the actual feasibility of processing a claim at the border and through what are very, very truncated procedures. It's not only a question of short time limits that are very restrictive for both authorities that need to decide and for the applicant to put forward a claim. There's also a very strong physical element that should not be overlooked. To give you an example, when it comes to the French border procedure, which is one of the member states that are actually quite actively contributing to the debate, in Paris, in Charles de Gaulle Airport, there is physical presence of the asylum authority. In all other areas where the border procedure is implemented, albeit with limited numbers, all conversations, discussions with applicants happen remotely. That means either video conference or telephone interviews. As you can imagine, the technical, even practical considerations that are attached to this are quite important, and they should not be overlooked. Still on the point of border procedures, one thing I think is important to mention is, again, the sort of persisting lack of proper understanding and knowledge. How much do we exactly know about how these things work in practice? To start from the basics, at the moment there are no EU-wide statistics on claims that are processed under the border procedures. This is not within the remit of the existing regulation that governs statistics, the so-called Migration Statistics Regulation of 2007. Interestingly enough, in the last couple of days, European Parliament and Council agreed on a revision of that instrument. So Parliament approved this last night, the Council last Wednesday. Now, this is a step in the right direction, although not with, let's say, a complete expansion of obligations to provide statistics, but there could be a few interesting opportunities there for all of us, I think, to think about what data, what information might be helpful and might be necessary for a better comprehension. One thing that is quite interesting in that regulation that should be adopted soon is the possibility for the Commission, so that's Eurostat, the statistical office of the Commission, to launch pilot studies, including on aspects like the border procedure. So this would bring member states to the table to actually get a system together that tracks how many people have their claims processed at the border and with what outcomes. Of course, alongside Eurostat statistics, EASO does a lot of that work, and the annual reports produced by the office also provide that information, but still not with the level of detail that would allow us to have the transparency and the understanding that we would need. Second legal point is on what EU jargon loves to call the variable geometry of it all. So CEAS, Dublin, Schengen are different pieces of puzzle of EU law that bind and have effect on different member states. So to make the picture as complicated as possible for you, we have examples of non-EU countries that are not bound by the asylum acquis, but that are Schengen-associated states and Dublin states, Switzerland, Norway, Iceland. We have EU member states that are bound by the CEAS and Dublin, but not in the Schengen area. So that could be Bulgaria, Romania, Cyprus. We have EU member states that are not bound by all of the acquis, but are in Dublin and they're out of Schengen. That could be Ireland. So any new proposals that come from the Commission that would affect this architecture, right, that would bring together parts of these instruments and make stronger linkages, as we heard this morning. Schengen, Dublin having closer links. This is also in the French non-paper a little bit, or linking asylum procedures and the Dublin regulation into one single instrument. These things should not be overlooked, because this is likely to redefine the legal relationship that these countries have with EU law. There will be a lot of adaptation, but as you can also understand, a lot of political implications for these countries. If it means that they have to get closer to something that looks like Schengen if they're not in there, etc. A very final point, without further ado, relates to how much of this is actually new and how much of this can actually help overcome the blockage. There's definitely an institutional impetus for change with new leadership in the institutions. I think that we can accept as granted. But on content, a lot of these proposals are old wine in new bottles. So initial assessments at the border, yes. What do we mean exactly? Do we mean something like pre-Dublin checks? And if we mean that, why would the member states that opposed pre-Dublin checks quite strongly back in the day, back in the 2016 and subsequent negotiations, why would they go for it now? Have we tackled the reasons for that opposition and for that stalemate? And this also relates to the final point that we heard this morning on the rest of the package. So as you remember, the asylum, the CEAS reform comprises of 7 legislative proposals, 2 of them very complicated and stuck in council, the remaining 5 quite advanced in terms of the interinstitutional negotiations, but not adopted yet. The question then becomes, if the Commission provides a bit of a push for member states and the Parliament to adopt these 5 proposals, first of all, would the opposing minorities in council accept this? Would they see this in their interest to let go of 5 proposals ergo lose quite a bit of leverage when they're still having to negotiate new proposals. And also, from the civil society perspective, the practitioner's perspective, but also the implementing state's perspective, what is really the added value of those proposals if they're adopted as standalone tools? We all remember that the package of proposals in 2016 was all constructed together by the Commission, right? And there were many elements that related to the vision on Dublin that permeated the proposal on qualification, the proposal on reception conditions, etc. Do we think there would be an added value in separating those and adopting, let's say, the reception conditions directive reform as it is now? From our perspective, there would be none. Because if we look at standards across the board, that would still represent a regression from what we have at the moment. There were quite a few efforts in the negotiations by co-legislators to remove some of the damaging provisions of the Commission proposals, but that still means, a step back from the acquis that is currently in force. I'll leave it at that, but happy to discuss and answer any questions. Thank you.